The American Land Title Association has just updated its minimum survey standards, effective February 23, 2011. I will let you know why these standards are necessary, highlight some of the more significant changes, and tell you why these standards may increase the cost of your survey. Why do we need surveys and minimum standards? Surveys are an important tool to alert you to title, zoning, and easement issues with a property. For instance, a survey can show you when your building or a driveway encroaches onto another property. An ALTA survey meeting these minimum survey standards is required by most title insurance companies in order to remove the standard survey exception to title policies. This certifies that the surveyed property is free and clear of survey matters except those disclosed by the survey. Survey standards are also important because they ensure a uniformity of quality, process, and information that is accurate, complete, and reliable, no matter where your property is located or which surveyor you use. Next, I want to talk about some of the more significant changes to these survey standards. Most changes are technical in nature, but here are some highlights. The new survey standards discourage the writing of a new legal description. They also require title commitment information to be shown on the survey and reinforce that the title commitment should be provided to the surveyor before the survey work begins. The standards require some indication of physical access to a public way, such as curb cuts and driveways, and to and from waters adjoining the surveyed track, such as boat slips, launches, piers, and docks. This used to be a Table A optional item, and now it is required. The survey standards also require a vicinity map, which also used to be a Table A optional item and is now required. It requires the use of a standard certification, unaltered, which requires the date of the fieldwork and the date of the plat or map. This short form type certification may pose problems for many lenders who currently require their own specific long form certification. The new survey standards also expand Table A optional items, negotiated by the client and the surveyor. While expanded choice of optional items is good for the industry, consumers should be aware that, as before, some of the additional items available in Table A may significantly increase the cost of a survey. Again, some former Table A items have been shifted to required items, as I previously mentioned. Highlights of Table A changes are: Item 6, zoning, has been split into two options that match zoning endorsement specifications, with zoning data to be provided by the title insurance company to the surveyor. Item 19 requires showing the location of wetlands. Item 20 addresses off-site easements or servitudes and the location of improvements in such off-site rights. Finally, Item 21 requires the surveyor to obtain professional liability insurance for the particular survey project and to provide evidence of such insurance if requested. This is somewhat controversial since many surveyors do not carry this type of insurance, and requiring it may create some sticker shock in the price of the survey. It is very important to carefully go through the Table A items and customize them to fit the needs of your project. If you have any questions, feel free to contact me.